It's my pleasure today to introduce Professor Bradley Smith. Bradley Smith is the Josiah H. Blackmore II and Shirley M. Nault Professor of Law at Capital University in Columbus, Ohio. Professor Smith is the author or co-author of 3 books and numerous academic articles on democracy and election law. His 2000 book, Unfree Speech, was dubbed, quote, the year's most important book on governance by columnist George Will. He previously held appointments as the Judge John T. Copenhaver Chair at West Virginia University College of Law and is a visiting fellow at the James Madison Program in the Department of Politics at Princeton University. Professor Smith served as commissioner on the Federal Election Commission from 2000 to 2005, and he was chair of that commission in 2004. He's going to speak to us today on Baker versus Carr and the power to vote. With that.
Thank you, Dan, and thank you those of you who have come out here in person and those who are taking your time to check in on Zoom. In his memoirs, Earl Warren called the Supreme Court's 1962 decision in Baker v. Carr the most momentous of his long decision as Chief Justice. More than such landmarks as Griswold v. Connecticut, Miranda v. Arizona, or even Brown versus Board of Education. This is not an inaccurate assessment. The one person, one vote standard enunciated through Baker, and more specifically its 1964 sequel, Reynolds v. Sims, has probably done more to change the institutions of American democracy than any other decision in the court's history. The correctness of the decisions are all but unquestioned today. Who, after all, disagrees with one person, one vote? Nevertheless, in this lecture, I want to offer a critique of Baker and Reynolds and suggest that while the cases did much short-term good, they have also altered our American democracy and how people think about voting and the purpose of voting in ways that are not entirely healthy. As Americans came out of the Second World War, 2 major problems plagued the structure of our democracy. The first was the outright denial of the vote to Black Americans, certain other racial and ethnic minorities, and occasionally even to their white allies through discriminatory laws, government discrimination in the enforcement of laws, or government toleration of non-governmental violence and harassment. Some of these problems were addressed piecemeal by the Supreme Court, both before and after Baker and Reynolds, and most were resolved with astounding effectiveness by the Voting Rights Act of 1965. The second problem was malapportionment in state legislative bodies. Malapportionment in this context refers to the unequal population of districts used to elect members of one house of a legislature. This malapportionment, the subject of the court's rulings in Baker and Reynolds, deprived no person of the actual ability to cast a ballot. Rather, the alleged constitutional problem was the inability of identifiable groups of voters to translate their voting strength into actual political power in the legislature. At the beginning of the 20th century, a majority of the United States population still resided in rural areas. By 1920, however, the US had an urban majority and the trend was accelerating. And the response in rural legislative majorities in many states was simply to refuse to reapportion the legislature. Maryland, for example, had not reapportioned since 1867, Minnesota since 1913. Calcified district lines in these and other states utterly failed to account for the massive shift in US population that began in the early 20th century. During the first 6 decades after 1900, millions of Black Americans moved out of the Deep South to the North and West and from intensely rural communities to the cities. Simultaneously, middle-class whites were moving from rural areas and inner cities to the new and burgeoning suburbs. By the mid-20th century, legislative districts across the country had radically different populations, so that the population of a district frequently had little correlation to its representation in the legislature. In Alabama, for example, a county with a 1960 census population of almost 51,000 had 1 representative in the legislature, whereas some counties with fewer than 13,000 were represented by 2 members in the legislature. Many of the worst examples came from the states of the old Confederacy, and the civil rights advocates argued that malapportionment, as much as the lack of voting rights, was being used to deny political power to Black Americans. But the problem of malapportionment was not limited to the South, nor simply the inaction. In progressive Michigan, for example, the state Senate districts enacted after the 1950 census ranged in population from 61,008 to 544,564. As a result, both Black Americans and the burgeoning white suburban middle class were underrepresented in legislatures when compared to their proportion of the voting age population. The problem was not one of voting rights traditionally defined, that is, the right to cast a ballot. These citizens could and did vote, or if they did not, it was due to legal impediments such as literacy tests and the like, of the type that would very soon be cold-cocked by the Voting Rights Act of 1965. Rather, the malapportionment problem was that the allocation of political power in the legislature bore very little resemblance to the percentage of urban and suburban voters in the population. Now, to me, it's remarkable how quickly Americans have forgotten the extent of this malapportionment. In fact, I was studying political science in college in the 1970s, just a little over a decade after these decisions, and I don't recall ever hearing a mention of malapportionment in American legislatures or what these decisions have done to change that. Let me give a few more examples. In Connecticut, state house districts range from a population with a high of 81,096 to a low of 192. In Florida, they range from 311,682 to 2,868. In Minnesota, they range from a low of 4,896 to a high of 359,982. There was one state house district in Vermont that had a population of just 24, truly a rotten borough that would have embarrassed any 18th century Englishman. The most populous district in the state, on the other hand, represented 35,531 people, a difference of almost 1,500 to 1. Moreover, in most instances, this was not a case where one house of the legislature was based on population and the other based on counties or some other geographic basis that led to these large population disparities. Rather, in most states, both houses were simply badly apportioned, whether or not they claimed to be apportioned on population or some other criteria. In 1946, in a case called Colgrove versus Green, the Supreme Court had held that apportionment issues were non-justiciable, beyond the court's reach. Justice Frankfurter, in a plurality opinion, argued that the remedy for unfairness in districting is to secure state legislatures that will apportion properly. But Frankfurter's argument, whatever its abstract appeal, lost its bite in the reality of the situation, because it fell to the very same malapportioned legislatures to do the reapportioning, and those who benefited from malapportionment, thanks to malapportionment, controlled the legislature. In most states, there were no apparent alternatives to asking the courts to address the problem. For example, in Tennessee, the site of the actual challenge in Baker v. Carr, the legislature had not redistricted since the census of 1901, even though the state constitution, in no uncertain terms, required redistricting every decade, and also required the districts to be drawn, quote, substantially by equal population. Efforts by governors to force the legislature to update districts had been unsuccessful. The state Supreme Court had held that the issue was, in agreement with the U.S. Supreme Court, non-justiciable. Thus, the state had no provision by which voters could consider a law or constitutional amendment without it first passing through the same legislature that refused to redistrict. In short, a minority of the state's voters had locked itself into permanent political power from which it could not be dislodged, and thus the pressure grew on the federal courts to act. But what could those courts do? As Frankfurter wrote in Colgrove, the action was not really, quote, a private wrong, but a wrong suffered by Illinois as a policy, Colgrove being a case arising out of Illinois. Should the Supreme Court get involved in the allocation of political power? And if it did, what kind of remedy could it dictate? Well, despite the thorniness of that question, the pressure got to the court, and in Baker, the court reversed course and overruled Colgrove, holding that redistricting issues were justiciable in federal court under the Equal Protection Clause of the Constitution. Solicitor General Archibald Cox, who was granted argument time in Baker, argued that the problem was the sheer irrationality of the state districting schemes. They were not justified by any democratic theory, but merely by legislative deadlock, inertia, or determination to retain minority political power. And this violated the Equal Protection Clause. But both Cox and the actual plaintiffs in the case argued against the court adopting any specific theory of redistricting that states would have to adhere to. Rather, they argued that the court should give as much leeway to the states in crafting districting plans as possible. Any rational plan would survive judicial review, Cox argued, and each state would have great freedom to apportion according to their own theories. Following this advice, Baker did not dictate a remedy. The difficulty with this rational basis or rational plan standard, however, quickly became apparent. Districting plans were soon challenged in 31 different states, and the district courts issued a plethora of decisions with various rationales, striking down 11 plans, upholding 4 others by the tort grant certiorari in Reynolds v. Sims. So in Reynolds, the plaintiff's lawyers were now divided on whether to stick with the rational plan formulation, still favored by Cox and thus the United States, or to push for the equal population standard, which was dubbed one person, one vote, although it really meant something a bit different from what it had traditionally meant in redistricting. It meant equally populated districts, which was not quite what the phrase had always meant. On the court, Justice Douglas and Brennan pushed hard for equal population, which they felt was both mandated by the Constitution and the most workable solution. And notwithstanding Frankfurter's famous warning that reapportionment was a thicket with no manageable judicial standards, equal population did seem pretty manageable. It made the solution to malapportionment for a judge one of simple arithmetic. Add up the number of people, divide by the number of districts, and require that many people in each district. And looking at the dizzying array of decisions coming out of the lower courts, one could see why the Supreme Court, having entered the thicket, latched on to equal population as the first exit out. And so in Reynolds v. Sims, the court held that districts must be equally populated. Now, the court did allow that adherence to local political boundaries, such as keeping all of a city, township, or county in a single district, might justify some population variance as long as the district was, quote, substantially on population and the equal population principle was not diluted in any significant way. But the court made clear that neither history nor economic and other sorts of interest, called them, were permissible factors on which to deviate from population equality, at least notwithstanding alone. And whether in combination these factors might come into play was not specifically said, but the tone of the opinion implied not, and later court decisions soon revealed that to be the case. Almost no deviation from strict population equality would be allowed for any reason, especially at the level of congressional districting. And thus, in one quick, rather intellectually chaotic swoop, the Supreme Court struck down as unconstitutional the legislative composition of nearly every single state in the Union. Now, Baker v. and Reynolds have one clear substantive virtue and one clear procedural virtue, which I've already hinted at. Substantively, the decisions put a quick end to the radical malapportionment that affected American legislatures. Whether this was truly necessary or whether the same political and social pressures that had caused the Supreme Court to reverse Colgrove or Congress to break the filibuster and pass the Voting Rights Act and Civil Rights Act would have done the job, we don't know. All that we can know is that Baker and Reynolds did get the job done. Procedurally, the virtue of equal population was, as I've noted, that it was readily administrable. And by appropriating the label one person, one vote, gained rapid acceptance with the public, although there is good reason to believe that then and even today, most Americans associate the slogan with the right to cast a ballot equal to that of any other voter in the same electorate and not to the demanding population equality across districts. But other consequences of Reynolds were less obviously beneficial and even perhaps detrimental to American democracy. An intended result of the court's equal population standard was to shift political power from small towns and farms towards cities and suburbs. Whether that actually resulted in better governance in the cities is unclear. Certainly, the early returns were not positive. The late 1960s and 1970s were an era of tremendous urban decline in America, although by many measurements, the suburbs, which also gained political strength under the rulings, did quite well. But policy changes often take time to manifest themselves, and by the late 1980s, a growing number of studies were concluding that reapportionment had, in fact, shifted government priorities in a way that favored urban areas. A revitalization of inner cities across the country beginning in the 1990s would be consistent with the idea that policies, perhaps resulting from greater representation in state legislatures, had begun to benefit urban interest. Correspondingly, however, many of the rural areas and small towns that have lost population under the lost representation under the equal population rule went into steep decline in the late 20th and early 21st century. And these now include some of the most economically depressed and socially distressed parts of the country. There's also some evidence that reapportionment caused a general increase in government spending, presumably due to the demand of urban and suburban voters for more government services. The reapportionment cases also affected the structure of government in ways that were probably not anticipated. For example, regional governing bodies often began to form in the 1960s to address issues such as water conservation and regional public transportation plans. Typically, these would include an urban core city and numerous surrounding suburbs and townships, and so that the suburbs and townships would agree to engage in the regional government without feeling that the big city would dominate the process. They adopted a federalist system in which each political unit has equal voting power regardless of population. After Reynolds, however, regional bodies based on this federal model cannot be directly elected by voters, as that would allegedly debase the votes of voters from more populated communities. Hence, Reynolds protected an undiluted right to vote by providing a disincentive to establish elected rather than appointed governing bodies to deal with regional and intergovernmental issues. Perhaps more seriously, the Reynolds majority noted that following political subdivision lines and districting may, quote, deter the possibilities for gerrymandering. Nevertheless, Reynolds and his progeny quickly made clear that concern for local political boundaries had to be subordinate to the one ring to rule them all, equal population. This meant that map drawers had to routinely break up political subdivisions. And that in turn meant that these boundaries were no longer a constraint on gerrymandering. There are innumerable ways, for example, to slice up or add to a city's population to get the right number of people in a district. And picking and choosing how to slice up the population is the essence of gerrymandering. It's exactly what the process entails. Not only political subdivisions fell by the wayside. Remember, the Reynolds court rejected virtually every other traditional districting criteria that had constrained gerrymandering, including history, economic and other group interest, compactness, geographic regions, assuring representation to unique but sparsely populated areas or to unique minorities, theories of bicameralism, balancing of political interest and rivalries, and even, as we will see, in states including Colorado, majority preference. With legislatures having a constitutionally mandated excuse to subordinate all other neutral objective criteria to equality of population, which can be sliced up any way the legislature wants, the apportionment cases have encouraged partisan gerrymandering, which now has become, of course, a hot topic for election reform. But perhaps the greatest long-term effect of Baker and Reynolds is also perhaps the most subtle. The equal population principle, I suggest, has played over time a significant role in changing how Americans think about voting in governments, and in ways not necessarily for the better. And to understand why, let's go back and look in more detail at the court's reasoning, particularly in the follow-on case Reynolds, which specifically articulated the equal population solution. The substantive portion of Reynolds opens with the statement, quote, undeniably, the Constitution of the United States protects the rights of all qualified citizens to vote. Well, that's undeniably true, but Reynolds was very careless in its description of exactly who was suffering injury through malapportionment. At different points, the court described the issue in the terms of the rights of qualified voters, or of citizens. But recall that the solution chosen was to apportion districts by population. Of course, equal population does not equate to an equal number of voters or citizens in a district. The census populations of a district will contain varying numbers of non-citizens, including lawful permanent residents, long-term but temporary visas, visitors, and undocumented aliens. Also, many citizens, including most obviously children, but also in different states and at different times, prison populations, persons with felony convictions, certain persons with severe mental disabilities, recent arrivals to the area, and still true at the time of Reynolds, those without property or some other direct interest could also be unable to vote. Thus, on its internal logic, Reynolds makes little sense. It declares that voters have to be exactly equal in their influence in selecting members of the state legislature, but then uses a different criteria, population, to determine how to comply with that. Now, this was almost certainly a consequence of practical considerations at the court. Most obviously, the court in the states lacked good data on citizens and voters in a district, but they had good data on population. Additionally, The political emphasis for redistricting that had led to Baker v. Carr had been the underrepresentation of classes of voters. But the court was not eager to be, or at least to be seen as, a political power broker determining the relative power of co-classes of voters. And the court was probably more comfortable at that time in writing in terms of individual rights than in the explicit reorganization or reordering of political power. And of course, the plaintiffs, perhaps sensing this last fact, have framed the allegation as one of individual rights under the Equal Protection Clause. Accordingly, the court defined the right at issue not in terms of group political power, urban voters, minorities, and so on, but rather in terms of the right of an individual voter to cast a ballot. Although, as we've seen, malapportionment didn't actually stop an individual voter from casting a ballot. This saved the court from directly engaging in the balancing of many considerations regarding the allocation of power that historically come into play in districting. It also allowed the court to buttress its entry into the political districting field by citing as precedent decisions in which constitutional violations were found, where citizens were denied the right to cast ballots, had their ballots intentionally altered or destroyed, or were defeated by fraudulent voting and ballot counting. The court concluded this opening salvo of irrelevant precedent by claiming that, quote, the right to vote freely for the candidate of one's choice is the essence of democratic society, and any restrictions on that right strike at the heart of representative government. But in the context of redistricting, that statement doesn't make it, it's kind of beside the point. No voter in Reynolds or any of its companion cases was denied the right to vote. Rather, as we've seen, the complaint was that some districts simply had more people in them than others. Now, the court tried to paper over this gap by asserting that, quote, the right of suffrage can be denied by debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise. Now, this at least begins to engage the actual question, the actual problem before the court, but it does so in a way that, again, Americans had never traditionally thought of one person, one vote. In the cases before it, each vote in an election was counted the same as every other vote in an election. Landlords didn't get more votes, or aristocrats didn't get more votes, or property holders didn't get more votes. And it's clear that the notion of unequally weighting voters in a single election would be a grave constitutional issue, and that was not controversial. But the court took a much more controversial position, the idea that population had to be equal across a wide variety of districts that might exist in a state. And this, again, as I've suggested, it is not clear at all, is what most Americans thought of as one person, one vote. So if the court's framing of the issue is off the mark, the court sensed intuitively that something might be wrong with such vast population disparities as I've described, and it might even have a constitutional dimension to it. The Tennessee district, specifically at issue in Baker, for example, ranged from 2,340 people to 25,316 people in population. The Alabama plan before the court in Reynolds had population variance between the smallest and largest district of 59-1. The court undoubtedly perceived such extreme population disparities as something not intended by normal anti-majoritarian features of both federal and state constitutions. But the court's articulation of all this was very confused at best. And two passages of the majority opinion in particular illustrate the court's failure to really grasp and discuss the issue. First, in casual, almost offhand prose, the court informed the public that, logically, this is a quote, in a society ostensibly grounded on representative government, it would seem reasonable that a majority of the people of a state could elect a majority of that state's legislatures. I don't think many people disagree with that. The statement, however, can be read in a number of different ways. One reading, what it seems to literally say, is that the voters who vote for a particular party, if constituting a majority of electors across the entire state, could elect a majority of the members of the state legislature. If a party's voters constitute more than 51% of the electorate, or 50% plus one, they ought to be able to elect legislative majorities from their party. Or to be, put it in less partisan terms, if the majority of the state's electors favor, say, a higher state income tax for funding on the roads, then the result should be that a majority of the state legislature would favor higher taxes and more spending on roads. But this reading doesn't address the facts of the case. In each of the states which were being challenged, a majority of the people could elect a majority of the state's legislatures. It just wasn't guaranteed to happen all the time. So that takes us to a second plausible reading. Maybe what the court meant was that a majority of the voters of the state favoring a particular party or policy should always, not just could, but should always elect a majority of the state's legislatures, and that the Constitution, in fact, requires that guarantee. But that would be wrong. Why would that be wrong? Because the unavoidable result of geographic districting, which the Supreme Court has never suggested is unconstitutional, and I think reasonably could not, is that a minority of voters voting for one party or faction at times may elect a majority of the legislature. If there are, for example, 5 equally populated districts, and one faction wins 3 of them with 60%, and the other faction wins 2 with 85% of the vote, the first faction will win a majority of those 5 seats. It will get 3 of the 5 seats with just 42% of the vote. This is not frequent, but it happens with surprising regularity, actually, in every democracy that uses geographic districting. In Canada, in the UK, in Australia, New Zealand, India, Japan, and of course, the United States and elsewhere. Alternatively, then the court might have meant that a majority of the state's legislature should represent areas constituting a majority of the state's population. This is further from what it said in the line I just quoted, but it is in line with the court's focus on population, if not its rhetoric about voters and citizens. But again, this was possible under all the plans before the court. So that takes us to what strikes me as the final interpretation, which is to say the only one that seems consistent with the thrust of the opinion and the prescribed remedy is that the court meant that any combination of legislators constituting a majority of the legislative body must always represent districts containing a majority of the state's population. But the court never explains why that should matter, particularly given that, as we've just seen, that prescribed remedy would not guarantee a voting majority. And of course, when the legislature meets and votes, it wouldn't guarantee that the legislators voting for any particular matter necessarily were from that majority of voters. Now, this hole in the court's reasoning becomes even more apparent when we consider other anti-majoritarian devices frequently employed by legislative bodies in state laws and constitutions, such as supermajority requirements, committee rules, bills of rights, other things that intentionally frustrate popular majorities. Both our federal and state constitutions and statutes and procedures are filled with provisions to make sure that majorities do not always win. The court's second poorly articulated claim in favor of equally populated districts was that, quote, legislators represent people, not trees or acres. Legislators are elected by voters, not farms or cities or economic interest. Okay, now here we see another truism that's being used to mask a difficult substantive issue. Of course, legislatures represent people, but the entire idea of geographic districts is that legislatures represent people who live amongst particular trees and acres, or better put, who live in specific farm communities, towns, and cities, and that these districts are often designed as proxies for capturing and hence assuring representation of certain economic and other interests. Geographic districting geographic districting has deep roots in democratic theory and in United States practice. The US has a long history passed down from pre-colonial England of selecting representatives on the basis of town and county. Population discrepancies between districts were historically quite normal and expected. The function of a representative was to take to the legislature the needs and desires of a particular community, not a specific number of people. A frontier community might need increased military protection. A growing port might need a road to service the interior. And these kinds of projects would arguably benefit all of the citizens of the state, but the legislature might only come to recognize them and understand such problems if they were presented by local representatives. Geographic districting assisted good government by assuring that local knowledge and interest would be brought into play in distant state capitals. As one commentator has written, people who live in close physical proximity inevitably share certain kinds of activities, and the bonds created through these shared activities give rise to a community of interest that is deeply connected to, built upon the matrix of, even induced by the particular locality in which members live. For these reasons, from earliest colonial times, counties and townships formed the typical basis of representation in American legislatures. It was presumed that communities, not individuals, would be represented in legislatures. These communities would in turn choose their representatives through the votes of their individual members. This notion of representation by community in turn flowed from English parliamentary history, where as far back as the 12th century, the incorporation of a town by royal charter was typically accompanied by the right to send members to parliament. That many of these rights of representation devolved over time into rotten boroughs, very few people in them, did not indicate a failure of geographic or the communal idea of representation, but rather the simple failure to redistrict, that is, to update the interest in places represented, even as communities waxed and waned. But here we might note that England eventually abolished its rotten boroughs long before the United States did, and never required precise population equality to get there. Perhaps the most radical aspect of Reynolds was the imposition of equally populated districts on both chambers of a bicameral legislature, which 49 of the 50 states have a bicameral legislature. Something like the US Congress, one house elected on population and another based on political subdivisions, that is the states, was prohibited to the states themselves. Now, of course, there are very serious arguments for using equal population, and these are touched upon in founding debates, and they are visible in the requirements for some equality of population in the Constitution or laws of virtually every democracy, and indeed of virtually every state. And as we saw, most of the US states that were so badly malapportioned had that kind of language in their statutes and constitutions. They simply weren't living up to it. Okay? But there are also certain reasons for deviating from pure population equality. And these are also reflected in the laws and constitutions of virtually every democracy, particularly those, as I've indicated, with a history in the Anglo-American tradition. Though declaring that equal population is, quote, the basic principle of representative government, close quote, in neither Baker nor Reynolds did the court majority even attempt to address the dissenting justices' historical analyses, which showed conclusively that equal population in both houses of the legislature was, to use the dissent's language, quote, not the English system, it was not the colonial system, it was not the system chosen for the national government by the Constitution, it was not the system exclusively or even predominantly practiced by the states at the time of the adoption of the 14th Amendment, and it is not predominantly practiced by the states today. Now, the founders, we might note, based state representation in the House of Representatives on population, and this, I think, indicates the importance they put on popular control on population as an important measure in a democratic republic. But even this included the important caveat that each state got at least one representative. So in fact, our US House of Representatives even doesn't have equal population. Coupled with rounding, this requirement of one representation creates disparities in population. In the 1790s, for example, Delaware had one representative for its population of 60,000, while neighboring New Jersey had 5 congressmen and one for every 37,000 people. Today, Wyoming, or Montana, I'm sorry, has almost twice as many people in its congressional district as do the congressional districts in Wyoming and Rhode Island. The federal Senate obviously had equal representation between the states, making it intentionally malapportioned from the start. Tennessee was admitted to the Union in 1794 with 1 senator per every 18,000 residents, while Virginia had 1 per roughly every 374,000 residents. The Reynolds Court wrote off this historical fact. It's just sort of a vague constitutional oddity that was the exception to the rule that was necessary to get all the states into the Union, and we would just have to live with that, but it wasn't intended anywhere else. Now, there's at least a little truth to that idea that this was just a constitutional necessity to get the Union off the ground, but it's deeper than that. There was a reason it was a constitutional necessity, and that is that the states cared about their status as sovereigns, and even more, they cared about that because of place. Georgia was not Massachusetts. New Hampshire and South Carolina had different needs, economies, and local customs from one another. Connecticut and North Carolina were not just different sovereigns giving up some of their powers to join the Union, they were different places that would have different interests in that union. And the smaller states were unwilling to subordinate their interests to those of other, more populous areas. Designing a political system in which minority interests always lose simply because they are in the minority is a sure means to political alienation. We can safely presume from what the founders did write about apportionment, and it's surprisingly little really, that most of the founders and drafters would have argued for equal population in districting, more or less. But that little phrase, more or less, does a lot of work here. The founders clearly did not insist on near perfect equality in population demanded by Reynolds, and there's no reason to think that those who ratified the 14th Amendment thought it altered that principle. Nor did they see equal population as a desirable attribute for both houses of a bicameral legislature, as indicated by the creation of the Senate. Thomas Jefferson, for example, was not at the Constitutional Convention, but he remained in regular correspondence with his close friend Madison and with others who were. In his notes on the state of Virginia, written between 1781 and 1783, Jefferson was highly critical of malapportionment in the Virginia House of Delegates, noting that the Tidewater region, with about 1/3 of the state's population, controlled 1/2 of the seats. And of course, Jefferson was from that smaller proportion that was underrepresented, we might say. And population differences between the regions ranged up to 17-1. And yet, in the very next paragraph in that essay, Jefferson speaks disapprovingly of the Virginia Senate because it, quote, is too homogeneous with the House of Delegates. The two chambers, he argued, should be based on different electorates. The whole point of having a second house is to introduce different interest into the discussion. And Jefferson believed that as a policy matter, the Virginia State Senate should be roughly proportional to population. But again, that roughly is not a trivial modifier here. In the end, he not only approved of, but thought it desirable that one house be elected to represent, if you will, in the terms of the Supreme Court and Reynolds, real estate, or as trees and acres. As Jefferson put it, the purpose of establishing different houses of legislation is to introduce the influence of differing principles. One house might therefore, this is not Jefferson here, but one house might therefore represent raw numbers and the other be apportioned on a different basis. Now, one reason you want these different interests in the legislatures, Jefferson indicates, is indicated in his very next paragraph when he gives us one of his more famous bits of prose. 173 despots, he writes, the size of the Virginia House of Delegates at the time, would surely be as oppressive as one. In other words, you need differing interest again, and you need to set interest against interest. And having different houses represent different interests is a way to protect minority rights and to prevent majority tyranny. This is simply Madison's 10th Federalist, right? One house is based on population and can vote out a minority government, but the minority has the ability to block the majority as well. And this all takes us back to Reynolds. In support of uniform population in both houses, the court pulled out a bit of dicta from an 80-year-old case that was not about voting, but was about the right of Chinese to operate laundries in the San Francisco area, a case called Griswold versus Hopkins. And in that case, again, in dicta unrelated to the real cause of the case, the court held or wrote, quote, the franchise is a fundamental political right because preservative of all rights. Now, and the court, by the way, has repeated that in many of its cases since. Of course, it can be true that voting out those in power who threaten to usurp rights is a way to preserve one's rights. But this approach only captures part of the equation. Unlike natural rights such as the freedom to speak or worship or the right to be free from unreasonable searches and seizures in your home and so on, the right to vote exists only within the context of a state-organized election. If voting can be a tool to preserve rights, it can also be a power that infringes on the rights and interests of fellow citizens if used to attack those rights through a legislative majority. Rather than think of voting then as a pure individual right akin to free speech or the right to privacy, we should think of voting perhaps more as part of the self-governance of a free people, a duty and obligation we owe to ourselves and to our fellow citizens, and something we voluntarily took on ourselves when we overthrew the British monarchy. And in a democratic republic such as ours, no person or group should be arbitrarily denied the right to vote, because that denial on arbitrary grounds improperly excludes members of the polis and thus violates the social contract. But beyond that, the Constitution does not impose a uniform theory of how democracy must be practiced in the states. For example, in Ohio, where I'm from, we vote for county coroner and county engineer. I don't really know how to choose the coroner, but I vote. Other states don't vote for that. Are citizens of other states who don't elect these offices deprived of the right to vote? Some states elect governors for 4 years, others for just 2. New Hampshire, with a much smaller population than California, has a far larger state legislature than California. Some states and localities are now experimenting with ranked choice voting and proportional voting. Some municipalities use at-large districts, others use ward districts, where each person represents that geographic district. In other words, states and localities allocate political power in hundreds of different ways. And this does not even begin to include the non-electoral features, such as legislative procedures and other rules in the states. Now, many of these decisions that are made about how to structure democracy are made precisely to protect rights or to account for unique features in state politics, including the protection of rights from voting majorities. Indeed, many things, such as free speech rights, we routinely place off limits to any voting majority. If we see bicameralism as a check on government power and a check that comes from having different interests and principles represented, then it's perfectly legitimate for a state to shape political power so as to protect minority interests, even if it is not legitimate for a minority to entrench itself in power in a way that it cannot be replaced and wield that power over the majority. And this is why Lucas versus Colorado General Assembly, a case decided on the same day as Reynolds, so stands out. As you might guess, the case is from Colorado. Colorado's malapportioned legislature had not been imposed on the state's voters by a legislature elected by a minority. Rather, it was approved in a statewide plebiscite. By a 68 to 32% margin, voters had rejected a districting plan in which both houses were based on equal population and approved a plan in which, by a 64 to 36 margin, in which one house was based on geographic districts and political districts. The successful plan, the one that passed, had been devised after prolonged public debate, including substantial involvement of political scientists and research sponsored through this university and others in the state university system. And what's interesting is that every county in the state, including the most populous counties, voted for the plan that reduced the political power of the more populous counties. The same thing had happened previously in California. There, the legislature had placed two plans before the public in a referendum. One, supported by Republicans, would have required an equally populated districts and provided for an independent commission to draw lines if the legislature failed to do so. The other, largely supported by Democrats, left the state assembly apportioned on the basis of population, but provided for representation in the state Senate by county. Los Angeles County, the state's most populous, voted for the first plan, but every other urban area in the state, including San Diego, San Francisco, and Oakland, major ones at the time, voted for the county system, the second system emulating the US Senate, reducing their own power in the state. Now, California and Colorado should have warned the Reynolds Court that voters may recognize the legitimacy of theories of representation and goals for representation other than those the court seemed to insist were the bare necessity, the absolute minimum for democracy. And voters in these states were prepared to accept less numerical representation than their population might, quote, entitle them to in the name of political compromise or perhaps even better governance in the state. If one starts with the theory that democratic government is not legitimate unless every legislative majority is elected from districts representing a majority of the populace, and that the Constitution dictates this singular theory of democracy, then the court had no choice to impose its equal population criteria over the self-governing citizens of Colorado and California, and their choice is revealed overwhelmingly in plebiscites. But if one starts from the assumption that democratic Republican government can exist in a wide variety of ways and can be structured in many ways to promote good governance, prosperity, and harmony, then these two states demonstrate the emptiness of the court's claim that equally populated districts are uniformly recognized as indispensable to democratic government. Now, Chief Justice Warren himself, while serving as governor of California, had been instrumental in defeating the effort to redistrict the state along equal population lines. In those days, he had argued that many counties were more important to the state's economy and general vitality than their population would suggest, and that protecting the state's vitality might require giving them, therefore, some disproportionate representation to make sure that their voices were effectively represented in legislative deliberations. This malapportionment, he felt, would benefit all parts of the state. He favored retaining the plan in which the Senate was apportioned on a county basis. Now, why was Chief Justice Warren's position so different from that of former Governor Warren? As governor, Warren had to consider the needs of his state as a whole. Although Warren would later claim that his stand at the time was merely, quote, a matter of political expediency, The fact is, as governor, he had to balance constituencies, urban and rural, north and south part of the states, parties and ideologies. He needed to govern a large and very complex state. And some would argue that that is exactly what politics and the decisions about representation are about. The votes in California and especially Colorado indicate the ongoing vitality of theories of representation that rely on other factors other than equal population or equal numbers of people in every district. But the court's solution was to hold that voting majorities could not control the structure of their government. If even one voter objected on the grounds of dilution, then the system would have to go. Talk about minority rule or depriving us of self-government and the right to vote. With Reynolds, the court changed, I think, the way we look at elections. True, districting process was widely abused pre-Baker, there's no doubt about that. But the idea that preceded that abuse of the idea that voting is a mechanism by which we govern ourselves may still be a good one. Voting is a means to an end, and that end is the election of competent officials and to gain good government for the polis as a whole, a way to peacefully resolve our disputes and move forward. Reynolds insisted that the citizens of Colorado, California, or anywhere else could not agree to a system of governance that aimed to assure better representation for marginal groups in society, or to guarantee that a wide variety of concerns and views are better represented in the legislature that are contributing to the benefit of the whole. The court's thinking was both a result of and encouragement to think of numerical majorities as the sole source of political legitimacy. Elections were not about good governance, but ultimately just about getting what you wanted out of the government. And if that's true, people soon begin to think that anything is okay if a majority vote for it. And hence the politics we have today, in which compromise seems abandoned in a desperate effort by each faction to put together a coalition of 50% plus one, and then use that to claim a right to enact whatever legislation one wants on the slimmest of majorities. A few years ago, I did a program for federal judges on election law with a colleague. And during the question and answer session, we were asked about the Electoral College, kind of a vaguely related issue. And my colleague, a Californian, answered that he thought it was absurd that citizens of Idaho should have more political power than the citizens of California. I was more diplomatic than this in my response, but I will tell you the thought that ran through my head was, are you out of your mind? Who thinks the citizens of California have less political power than the citizens of Idaho, either individually or collectively? The pure size of California's congressional district or delegation will give it more power. It has large newspapers and the media and Silicon Valley and Hollywood. It shapes culture, it shapes the economy. And moreover, it's at the seat of power, whereas the citizens of Idaho are thinly scattered throughout the state, making it much harder to actually organize yourselves for political action. Well, at this level, or at a lower level, the same is true in many of the states. The idea that the more populated cities have less political influence simply because rural areas might get a slight increase in per population representation in the legislature strikes me as wrong-headed in the extreme. Today, many of America's worst pathologies can be found in rural areas, beset by brain drain, loss of jobs, opioid addiction, and more. Might voters in some state not conclude that it would be beneficial to increase those areas' representation in the legislature? Or might, in the name of equity, a state conclude that added representation of indigenous communities, reservations, and other tribal areas makes sense? Something our unenlightened neighbors in Canada, by the way, do. Might Governor Earl Warren have been correct, more correct than Justice Earl Warren, arguing that a proper balance of the state's economy and prosperity relied on giving certain areas a little bit of an extra voice in the legislature? There are many more such questions, but all of these are now off the board due to Reynolds and its progeny. It is interesting to think what might have happened had the court stuck with the rational plan supported by Attorney or Solicitor General Cox and Baker. Yes, in the immediate aftermath, the lower courts were going all over the place, but I wonder if the court had simply issued a couple decisions talking about what types of districting decisions were so outrageous that they could not pass constitutional muster, would not have quickly led to a general consensus on what was something that a state could not do. But we won't know how that might work. In conclusion, though, we see an old tale. In solving one problem, Baker and Reynolds created new problems, putting American self-government in a straitjacket from which it really has no sound constitutional, for which there was really no sound constitutional basis. There's no reason that Americans should be stuck in that straitjacket, but except for the fact that the court has no real mechanism to back off. until some legislature is willing to pass a plan that they presume the court will strike down as unconstitutional, there's no basis to challenge it and for the court to reconsider its decision. And so perhaps then the ultimate decision we learned from Reynolds, at least the immediate decision as we go forward from here, is that as we approach the 60th anniversary of these cases, we should beware of seeking sweeping judicial decisions to political problems. More and more today, these questions of how we structure our democracy are brought to the federal courts rather than left to be resolved by democratic deliberation and debate. And we may find that by putting these in the courts, we create problems that we don't anticipate and that will not help us out over the long term. Thank you very much.
I have a question for you.
We have questions.
It sounds like you end up supporting a kind of pluralism. That is an idea that states should be allowed to decide these questions on a variety of different bases, and maybe even you suggest that we should stick to just any rational basis, which is the lowest, isn't it? The lowest standard of I can hardly think of a lower one.
Right.
Just
yes,
irrational whim or something,
right,
or something like that. Are you willing to go that far, or is that just a limiting?
Yeah, no, yes, I am. I do think that would be some of the criteria. Now, again, you're going to need court decisions to decide what is a rational basis, and we might disagree with some of those decisions. But generally, again, that approach is saying the states have as much leeway as possible, I think is good. And I would note in response to the question, which is a good one, that often when I make these remarks, at least to more conservative audiences, the attack I get from the other side is, well, why are you willing to let the courts do anything, right? On what basis do the federal courts interfere with state districting decisions at all? And I have a whole nother, 45-minute lecture I'm not going to give about why I think that's the case. But suffice to say that I do think, it is not healthy for democracy either, nor can we really go forward with populations, just variations of 50 or 60 to 1 routinely appearing in legislative schemes. So it would become a difficult issue. But part of the point is that we've never had a real chance to debate that issue and to debate what, if any, limits there ought to be, because Reynolds precludes that debate. I have louder audience. Here's a question.
Yeah. So I'm a Western American historian, and I can figure that out as well. But anyway, so I'm a Western American historian, and I would keep encountering Baker versus Carr when I thought about urban-rural tensions in the American West. And then I realized I was over my head when I was trying to hear it. So this has been very providential to have you speak now. But I'm just wondering, what if one had a hope about urban areas and rural areas actually seeing each other's interests and seeing them as intertwined? Is there something in the configuration of voter allocation that would lead to that? Let's not have rural areas overpowered and left to have the problems that you just described, but let's have the urban areas notice that there's, or the residents and citizens in urban areas notice that there is some reason to be in common ground. I mean, so I guess what I got from my primitive efforts to understand this, but they're better, I've been doing better now after listening to you. But I'm just wondering, is there something that would have been a form of thought that would have reduced the urban versus rural and maybe increased it some kind of urban and rural? Is there any allocation that's not population? Because that doesn't seem to be the thing to.
Well, I will say I don't know of anything that I would say is formulaic. I do think it can depend on different states. Let's take what I consider sort of easy examples, and they're not quite the examples you've raised. But for example, Hawaii. Why wouldn't Hawaii want to say, each inhabited island gets a certain minimum number of representatives so that they're not all overpowered by Oahu or something like that? or Michigan with its Upper Peninsula. And these are not, by the way, original ideas of me. These are ones actually raised by the dissent in Colorado Assembly, the case decided on the same day as Reynolds. That states sometimes have this. And you see this elsewhere, by the way. For example, England gives extra representation to some of the small islands because each island gets a representative. It retains that old idea of place. So you have thinly populated areas. In a state like Colorado, it might exist around geographic areas, mountains cut off parts of the state and so on. There might be things like that make sense. What's kind of interesting to me, I don't know if there's any one answer, but I do think it's interesting that isn't that largely what the citizens of Colorado did in that 1962 plebiscite? They basically said, let's look at this as what's kind of good for the whole. And similarly, California. Now, and in California, by the way, there's always the dynamics. In California, part of the reason San Francisco and Oakland were willing to let their own numbers drop over what they might be was because they wanted to ally themselves with the rural areas to beat back Los Angeles, which was growing and growing and growing. And San Francisco had always been the dominant city in the 19th century. And so you do have a lot of those things come in. I mean, we have to be realistic. I have to be realistic. There is raw power politics coming to play. And that's part of the reason I do think there's some reason or some ability for courts perhaps to step in extreme cases. But I think over time, as we think about it, your question's a good one, your point's a good one. And the only way we get there is by appealing to people on that basis, by talking again about why do we vote? Is the purpose of voting just to get absolutely as many people to vote and make it as easy as possible for them to vote? Or is the purpose of voting to make sure that everybody who wants to vote can vote and has the ability to vote, but votes thinking about the entire community and what is good for our state as a whole or our community as a whole. And I don't know that there's a magical way to get there, but I think one way to start is to move away from the idea that you have sort of an individual right that nobody else can infringe upon in the same way, again, you would have a right to speak or to worship, or again, to be free from unreasonable searches and seizures, or maybe a Second Amendment right or something like that.
There's a question from the virtual audience that's a good follow-up to this, I think. Someone wonders whether you think that the idea of making it as easy and inexpensive to vote as possible, not that really inexpensive, but is a good one. Is that an ideal that you would support?
Well, let's put it this way. I would definitely oppose any effort to intentionally sort of make it hard to vote, but I don't think the goal of voting is to make it as absolutely easy as possible. And let me say what I mean by that. For example, in line with what I'm saying, I think it's that the presumption should be that people vote in person on election day. And I realize I'm saying that in a state that does all of its elections entirely by mail. But, I think there's something good about sort of everybody voting at one time with the right information. You can make a counter argument. It might be better if it's spread out and, people aren't voting so much on what happened the weekend before. But I kind of liken it to, imagine if jurors could start voting partway through a trial and just start checking, but they couldn't change their vote once they made that vote. Meanwhile, evidence keeps coming in. I don't think that would be really good. And to me, that's a little bit more how I think about it and why we should try to encourage voting close to or on election day. We should make, in my mind, like absentee voting relatively easy. I wouldn't be exacting or demanding, but personally, I don't think I would go to no fault absentee voting. And by the way, there's not much evidence in the end, although it's easier, that it really increases turnout. Moreover, absentee ballots, up until a year and a half ago, have been entirely uncontroversial to walk into any symposium and say absentee ballots have a higher rate of fraud than in-person voting. They do. It's not a high rate of fraud. I don't buy into those kinds of theories at all. In fact, I constantly am telling people, no, I don't think there's much fraud in American elections. But I do think it's higher in absentee ballots. But here's the other part of that. Absentee ballots also get rejected at a higher rate than in-person ballots. And part of the reason for that is that there's nobody there to help the voter. If they screw it up, they've screwed it up and it doesn't get counted. It's not a high percentage again, it's a relatively low percentage. But on both of those, sort of at the margin, it's a reason not to do it. So to answer that question, when they put it, do you favor making voting as easy as possible? In some sense, I don't even know what that means. Does that mean a government worker has to go to your door with a ballot, knock on the door, say, here it is, would you like me to fill this out for you? I mean, as easy as possible has to have some limiting principle on it. But I do think it should be easy for people to vote. It should be convenient to vote. But I do think that, the purpose of an election is not simply to get as many people to vote as possible. And I think that in the end, we should try to encourage habits of voting and the way we talk about voting, talk about civic responsibility, duty, our obligations as citizens, and our common good, that we should remind ourselves, this is such an amazing thing that hasn't existed for most of history in most places, that we go out and we vote on these things. And we have far more in common than separates us, which we often totally forget. So I think we should think about voting in those terms a bit more often.
I can't resist following up briefly by asking if it's a responsibility. What do you think about Australia? That is, maybe what do you think about making it a legally enforced responsibility?
Yeah, well, this is interesting. I know we have one person who is an Australian in the audience here. Also, I've observed elections in Australia, and one of the things I observe is that Australia, I would note, doesn't really require you to vote. They require you to show up at the polls. And they get a fairly high percentage of spoiled ballots that you can tell are a lot of people who either don't know how to vote, or they resent the fact that they've been told they have to vote, and they either don't fill out the ballot or they just put one line through it. And probably a higher percentage than I might like, sort of what I call dumb ballots. For example, for certain offices there, they use ranked choice voting, so you rank the candidates. And you see more ballots than I would like to see, and more than I think would be statistically likely, that just go 1, 2, 3, 4, 5 in their choices. The people are listed. And that doesn't mean those people didn't rank them in that order, but you kind of wonder sometimes. So I'm not sure how well that works. The one thing that it does that may be very useful is it does mean they keep very good registration rolls. The government makes sure everybody gets registered, and you don't have this kind of private effort to register people. And there may be some benefits to that. I'm a bit mixed on it. Deep down in my little libertarian heart, I say no, but I do think there are some rational arguments for it.
Okay.
The Australian.
Actually, I was going to talk about something else but I'll add on the Australian thing. You cannot vote, and all you have to do is just make up an excuse, and nothing will happen. So there's lots of ways to get out of voting. But anyway.
And I believe, correct me if I'm wrong, but I believe, if I remember right, when I was there in 2004 for the issuance, the fine, if you didn't vote, was like about $50 or $35. I mean,
it's on a Saturday. A lot of people have other activities on Saturday in Australia. But I won't mention it. But, yes. I was going to ask a question about, you talked about the question is making it easier for people to vote, but I'm thinking of the other side, like making it easier or providing better incentives to get more candidates and more variety of candidates with more political views. Like we're kind of stuck in this two-party system here. I'm like, just sort of what your opinion about that is. Would that help? You think moving away from that would kind of help what we're saying or not? Like completely off track here.
I don't know. When I was a very young person, I chafed at the two-party system. As an older person, I became much more and more of a fan of it. Although I think that we had a number of laws that sort of legally entrenched that system, which were not good. I think any system that relies on sort of single-member geographic districts, right? You live in a district, you have one congressman or one senator or one state representative, does tend to fall into a two-party system, because everybody says don't waste your vote. You eventually pick which of the two candidates are most likely to win that's closest to you, even if they're fairly far away. But I think we need to avoid having laws, which can include campaign finance laws and ballot access laws and some other things that tend to entrench those two parties. It would be almost impossible to start the Republican Party was formed in like the spring of 1854 and captured a majority of the U.S. House that fall. You couldn't do that now. In fact, for people people who don't remember all the way back to 1854, it only can go back to 1992 or 96, for example. Remember Ross Perot running, and he started the Reform Party, and that didn't last, but it did elect the governor of Minnesota. It did elect a few other people. It had a U.S. senator at one time for a brief few months. You couldn't start a Reform Party because of the passage of the McCain-Feingold bill in 2002. That made it pretty much impossible to start a Reform Party, although some court decisions since then have eviscerated some of that. So I think we need to avoid laws that truly entrench that two-party system. So the idea is that, there's two parties, but they can swap out with that third party, and they're not the same two parties entrenched forever. I don't know if that answers your question.
Can I just ask one? I'm thinking, and also thinking about quality of candidates. I mean, I don't know. This is anecdotal evidence. I think the quality of candidates are pretty poor in the United States. And I'm just thinking about what's ways to get better quality people to run for election. Is that a way to improve the system, more abstract away from what you were saying?
Again, there's a lot of things that come into play. I mean, for example, a lot of things are pathological within the legislatures themselves, what our leaders have done in part to try and get through legislative agendas. So I think that's in part because we've lost this idea of compromise. So you got to do everything on a partisan basis. So more and more you see these, parties trying to jam everything through in one big sort of omnibus reconciliation bill that's done with no amendments allowed and that sort of thing. And what happens when you get that is that I think a lot of people who would like to be serious lawmakers decide they don't want to really stay in the legislature. And instead, what you have is people who are show horses who want to, at the federal level, the congressional level, they want to be on MSNBC or Fox News or whatever it is, as much as they want to sit around and do the tough work of writing bills and trying to figure out how to develop compromises. Now, I don't mean to suggest that these are easy things, to solve. I mean, they're slow cultural changes that have taken place over many years, and I think they'll be very hard to get out of. And to some extent, by the way, it's the old line from the old comic strip Pogo that probably nobody remembers. We met the enemy and it's us, right? I mean, we're the voters. This is who we return to office. I will tell you that I'm personally here. I get really on them. I'm not a big fan of primary elections because I think actually that I'm not sure that there's much evidence that you get better candidates out of primaries than you do from having, sort of party operatives, people who have a long-term interest of the party and who are thinking about winning general elections come into play. But all of these things, the great thing about the US is we should have 50 states that can experiment with all these things. And when you talk about the one person, one vote standard, again, the Supreme Court has cut that off. Every state now must use exactly equal populated districts for both houses of their legislature. So to kind of take it back to my original point, I think that, on all of these different kinds of things, mandatory voting, maybe even, whether to have primaries or, all kinds of different things, I would like to see more, allowing more diversity in the states.
Yes, right. I got preoccupied with how many times you and others have used the word think. And that caught my attention because, and for very understandable reasons, you were saying, if we would think about this or if we would think about that. And that brought to my attention that that's what worries me the most about voters is the not thinking part. And
I was afraid you were going to tell me you were going to demand that I come up with some action here, Smith.
No, you're thinking very well. But I realize that's the part that makes me the most crazed is that, look, I think my first thought would be that I'm angry at the voters for not thinking more before they vote about ballot initiatives and so on. But then I started thinking about ballot initiatives and I think that might be the problem. And I remember, I can't remember the author, but I remember 25 years ago, some author wrote a thing about how many advanced degrees you would need to vote intelligently on one election ballot of California initiatives. And it was many, the electrical engineering part was very hard. There are all these things that you would just really, to vote intelligently, to think about ballot initiatives, you really would have to have 14 advanced degrees to do that well. So that's made me think that that it's the structure of what they're voting on or what they are given to vote, and initiatives and referendum would be, I guess, the main point on that, but that it's how can we expect people to study? We can't even expect our students to study sometimes. So how do we expect people to study in order to look at those? I love the people, I've got to meet them several times, who write the blue book things that give you the alternative arguments about what an initiative will mean and who support. I love those people, but I don't know that anyone reads the things that they work. So is there some form of deciding who is going to vote when that would accelerate the invitation to think before voting? Or is that just hopeless utopian practice?
Well, this has certainly been something that's been raised for a long time, and of course, it's dangerous for us to start thinking that the government will decide who's good enough to vote. That's back to the days of literacy tests, and then those things. Not only are they maybe bad in themselves, but they're also readily abused for other reasons and that sort of thing. And having said that, I mean, political scientists do look at this kind of thing a lot, and obviously here is one thing where sort of proxy voting comes in, or cues. So. They used to say, people used to say things like, there's not a Republican way or a Democratic way to pick up trash. And I would often say, of course there is. The Democratic ways, you farm it out to corrupt unions, and the Republican ways, you give it out to corrupt private companies. And there's two different ways. And so voters can in fact make those decisions just by saying, I tend to align myself more with this party than with that party, or something like that. And to some extent, that's what we rely on. But I have to tell you, I mean, I can agree. I'm not a huge fan of plebiscites. At least on a certain, on very complex sort of legislation, probably on amending our state constitutions, because that's what we did originally. Then we're talking about sort of our core organic law, and hopefully have a good, serious debate. But I think the kind of bill you're talking about is, the 27-page, item that regulates, offshore oil drilling in California or something, or we had one in Ohio a few years ago about legalizing gambling. And I suppose the voters probably could look and say, yeah, I think we should legalize gambling or not. But this went far beyond that to have right in the state. So we have now in our state constitution the precise location of the casinos in the state. This is the kind of thing, the detail that you really need in a state constitution. But of course, they want it in the constitution, not in just a legislation, because if it's in legislation, the legislature can change it. Once they write it in the constitution, now the legislature can't change it. And I think that kind of thing is ridiculous. How do you get a handle on that? In states that have plebiscites and so on, you may need to have a constitutional amendment to change the types of subjects that can be put on the ballot in that fashion.
We have time for one more question. There's one more question here in the queue. Someone wants to know what you think about the idea of depoliticizing redistricting. Is that realistic, or is that?
Okay, I assume that refers to things like nonpartisan commissions and so on that do this. And again, one thing I mentioned, I mean, again, a state might decide, because it thinks gerrymandering is a great evil, that we want to go back to using county lines or something, even though that's the gerrymandering is more of an evil than having unequally populated districts. You can't do that now. I think, again, I feel like it's great if states want to experiment with these committees. Most of these commissions have these kind of Rube Goldberg systems to try to make sure that nobody could ever take it over for partisan purposes. And it doesn't seem to work. I mean, there's almost a joke among election lawyers that they're reasonably nonpartisan once. And by that time, and then by the second time around, the parties have figured out how to play the system. And it's all jockeying for position. So color me a skeptic, but not one who's opposed to states experimenting with this, or, who would necessarily be opposed to any particular proposals that were made in my state. Thank you very much.
Please join me in thanking Professor.